Good morning. Welcome. It is a shame that when you come to the West Coast, we don't get to inflict on you the same pleasure as when we fly east for all the conferences, and there's a 9 a.m. panel, which is really, or like a 8 a.m. panel, which is really a 5 a.m. panel. But anyhow, welcome to Stanford. And I'm really excited to be sharing this panel with 3 very accomplished historians in various stages of their careers. So we're going to go, as you just heard, in chronological order. So we're gonna start with Anne Twitty, who is a historian of the 19th century U.S. with a particular focus on law and legal culture, slavery and freedom, and the history of the South in Midwest. Her excellent first book dealt with freedom suits in Missouri. She was previously at the University of Mississippi and at the Kinder Institute for Constitutional Democracy at Missouri, but now we are fortunate to have her join the department here, the history department here at Stanford. Next to her, Spencer Weinreich is a junior fellow at the Harvard Society of Fellows and a lecturer on the history of science. His work sits at the intersection of history of science, carceral studies, and the history of Christianity. And he has a book that will hopefully be forthcoming soon with Harvard University Press called An Experimental Box, A History of Solitary Confinement. And then Carolyn Ramsey is a professor of law at University of Colorado Law School, teaches courses on criminal law, criminal procedure, domestic violence, gender issues, and legal history. She has been trained at the best law school in the country, Stanford, and also received graduate training here as a social historian. And the paper that she's presenting is drawn from her forthcoming book, and I had the pleasure of actually reading the introduction and the whole chapter from the book, so I'm really excited to see the whole book, entitled Houses of Pain, Domestic Violence and Legal Intervention in the United States, 1872 to 1994. Okay, so I'm leaving out, there are many myriad other awards and accomplishments, but I think those will become apparent why their myriad accomplishments become apparent as we hear their outstanding scholarship. So let me turn it over to you, Professor Twitty.
All right, thank you, Greg, for the introduction, and it's exciting to get to kick things off here today. So my presentation today is drawn from a chapter of a book manuscript in progress that is tentatively titled Emancipating the North, which challenges longstanding notions about when and how the North became free. Part of this project focuses on what I consider to be the failures of the so-called first emancipation, which occurred when a number of northern states, Pennsylvania, Connecticut, Rhode Island, New York, and New Jersey, adopted gradual emancipation statutes between 1780 and 1804. These statutes declared children born to enslaved mothers free, but bound them to service until they reached a specified age, an age which varied typically from state to state and usually by gender, with women usually freed before men. Some of those subject to such statutes, individuals sometimes referred to as term slaves or the children of gradual emancipation, were not in fact released from bondage when they came of age. They were instead sold south before they attained their actual freedom, and there they were held as slaves for life. Indeed, the fact that gradual emancipation statutes worked so gradually incentivized or at least facilitated such conduct. On occasion, after they were carried south, these northern term slaves sued for their freedom in southern courts, thereby forcing southern jurists to reckon with northern gradual emancipation statutes. And it is these decisions that I explore in the chapter that I'm presenting today. Now, despite the relatively small number of appellate decisions in such cases, they provide, I think, a really fascinating window onto a whole host of related issues and dynamics. To begin with, these cases reveal a judiciary contemplating the South's possible future. Across early national and antebellum America, indeed even into the Civil War, many, if not most, white Americans believed that if slavery were to come to an end, gradual emancipation would be the mechanism. As such, when Southern jurists adjudicated freedom suits based on Northern gradual emancipation statutes, they weren't merely attempting to sort out how to apply those specific laws, but rather anticipating what might actually be in store for them further down the line. They were directly confronting slavery's long-term fate, a fate that they were often themselves deeply invested in. These cases also show a judiciary that sensed that particular outcomes might wreak havoc on slavery, but couldn't easily decipher what the consequences of the reasoning and decisions in these matters might be. Although Southern jurists were by and large pro-slavery, they struggled to figure out how to best protect the institution. So in these cases, we see their creativity at work. They try on a number of different analogies and interpretations, and they differ among themselves over a whole host of issues. More concretely, Southern appellate decisions in freedom suits based on Northern gradual emancipation statutes reveal a judiciary struggling to describe the particular kind of unfreedom that those who were subject to gradual emancipation statutes experienced, whether and how gradual emancipation statutes altered the condition of their mothers, and far-reaching issues of citizenship and comity as well. And I want to consider each of these legal issues in turn, which I discuss in the chapter as a whole. In broad strokes, Southern freedom suits based on Northern gradual emancipation statutes forced Southern jurists to puzzle over the status of those who were subject to such laws and the various forms of unfreedom that existed alongside slavery. At issue here was how to describe the status of the children of gradual emancipation with a particular fascination with the kind of nebulous in-between character of their bondage. Here, jurists groped for the right terms and analogies, but those terms and analogies had implications for how jurists understood both gradual emancipation statutes and those who were subject to them. For one jurist, the children of gradual emancipation had what he called an incipient right to freedom, but that would only be consummated by the attainment of an age that was specified. Now, having an incipient right to freedom implied that plaintiffs were not actually born free, no matter what the gradual emancipation statutes actually said. Another jurist described term slaves as qualified servants who were retained in a state of pupillage and should stand in the same relation to their superiors or masters as that of indentured servants or apprentices. So term slaves were like indentured servants, they were like apprentices. Alliteratively describing their period of term slavery as one of, quote, custody, curation, and consequential service, the same jurist then reinforced the notion that these children born to enslaved women after the adoption of a gradual emancipation statute were akin to indentured servants and apprentices and were specifically in need of paternalistic guidance or care. The analogies got more fanciful still. One plaintiff in Louisiana was declared a statu libera, a term the Louisiana Civil Code employed to describe slaves for a time, one otherwise used to describe, for instance, those who were enslaved but who would be freed at a later date, usually as a result of a provision in a master's will or some other legal form of document. So they were like individuals who were going to be freed when they attained a specified age. But again, this analogy really, I think, stresses that these individuals are not born free, but they are really more akin to enslaved people during their term of service. Finding the right way to describe and make legible the peculiar status of the plaintiffs was no easy task. As these jurists wrestled with linguistic limitations, moreover, I think they also anticipated a similar problem that has confronted historians of these laws, who tried to invent a whole vocabulary of their own to describe who these people were and what their status was. So, for instance, we get scholars of gradual emancipation statutes referring to these individuals as those born free into servitude, or statutory slaves, or slaves for a term, or probably my favorite term, the children of gradual emancipation, a term that I associate with Sarah Groening-Sater, whose long-awaited book is about to arrive, I think, finally this year. One of the reasons that I think I like that term more than so many of the others is that it doesn't even attempt to really describe the bondage that these people are subjected to. It simply says these are individuals who are subject to these gradual emancipation statutes. So this is, I think, a challenge born of this kind of anomalous status, one that sits very uneasily at the intersection between slavery and freedom. Now, in addition to exploring the status of children of gradual emancipation, Southern courts that adjudicated these freedom suits also, on at least a couple of occasions, examined whether and how such laws altered the condition of their mothers. These were women who were born into slavery, and these were women who would have continued in slavery as a result of gradual emancipation statutes, because they were born before those gradual emancipation statutes were adopted. So in a sort of obvious sense, it seems as though these gradual emancipation statutes aren't really affecting these women at all. But in another sense, an essential attribute of these women, perhaps the most central attribute of these women from the perspective of their masters, was unavoidably changed by gradual emancipation statutes. And that is because these laws altered the operation of one of the longest standing and most dearly held legal principles of American slavery, the principle of partus sequitur ventrum, literally that which is born follows the womb. This is the legal principle that ensures that slavery in the Western Hemisphere is both hereditary and descends matrilineally, that is through the mother's line. And unlike enslaved women across the United States, these women, those living in gradual emancipation states, could not transmit their status to their children. Or could they? This was one of the questions that Southern courts occasionally wrestled with. What happened when a woman who lived in a gradual emancipation state was carried to a state where no such laws existed? Had gradual emancipation statutes made her womb permanently free? The courts gave two conflicting answers to this question. In the Children of Sibley, an 1809 Kentucky Court of Appeals case, the answer was no. Sibley, a woman who was born in Pennsylvania before the adoption of the gradual emancipation statutes, was then later taken to Kentucky. And she was an enslaved woman living there in a slave state when, in fact, she gave birth. It made no difference, according to the court, that she had once resided in Pennsylvania, which had decreed that women like her could not pass on their status to their children after March 1st, 1780, because that condition only applied as long as they remained within that state. A generation later, however, in a case called Spots v. Gillespie, Virginia's Supreme Court of Appeals was less sure. Hannah, who had also been born in Pennsylvania before the adoption of its gradual emancipation statute, had, according to the court, been transformed by the law nevertheless. As court president Francis Brooke asserted, the statute might and did change the character of Hannah's master's property in her, and insofar, her condition as a slave. Before the passage of the Act of 1780, Hannah's master had an absolute property in her and her children then to be born. Afterwards, though his property in her was, as to her services, the same, her condition was so changed that she could not be the mother of a slave in Pennsylvania, and his property in her to that extent was changed. But was this transformation made by Pennsylvania's gradual emancipation statute absolute and immutable, or was it conditional on her continued residence in Pennsylvania? The court conveniently dodged this issue given the facts of the case, but I think it was clear that the matter was not so clear-cut as its sister court had suggested nearly 2 decades before. Now, in addition to attempting to define and analogize the status of those born in the wake of Northern gradual emancipation statutes, or to imagine whether these laws may have altered the condition of their mothers, Southern jurists in these cases also confronted the possibility of Black citizenship. This issue was, in fact, at the heart of a case called Amy v. Smith, a freedom suit adjudicated by the Kentucky Court of Appeals in 1822. The case ultimately hinged on whether Amy had ever been a citizen of any one of a number of states that she had inhabited, and as such could avail herself of the privileges and immunity clause of the United States Constitution. Amy versus Smith is an exceptional case. The underlying facts are extraordinarily complicated, and I'd be happy to give you kind of a Cliff Notes version if you're curious in the Q&A. And the case is also much longer than all of the other appellate decisions in similar such matters. But as in other decisions on Southern freedom suits based on Northern gradual emancipation statutes, what we find is a judiciary at odds. And that's because Amy versus Smith is the only such case, the only such appellate decision in a case like this that actually generates a dissent. So the majority in Amy v. Smith concludes, anticipating Chief Justice Roger Taney's decision in Dred Scott 35 years later, that Amy had never been nor could be a citizen. But the dissent offered a very different reading, a very capacious, imaginative reading of Pennsylvania's gradual emancipation statute. Quoting and paraphrasing freely from the law, Justice Benjamin Mills insisted that it was, quote, impossible to read the preamble and the whole act and to see the glow of liberty that burned in the bosom of the legislators and suppose that they had intended to keep anything back. Could they have been asked for an exposition of their own transactions? Could we get them back in front of us and ask us what they were trying to do, Mills asserted. And could we inquire of them whether they intended to make citizens or aliens of these creatures, or a kind of nondescripts, neither citizens nor aliens, but subjects of the Republic? They, he said, would have responded unanimously that they meant to make these individuals citizens. So though the authors of Pennsylvania's gradual emancipation statute had not used the term citizens, he argued, they, quote, placed the substance there, which will remain the same whatever terms subsequent instruments or constitutions may have employed. right? So in this particular case, the claim is that Amy becomes a citizen of Pennsylvania as a result of the Pennsylvania Gradual Emancipation Act. And once that citizenship applies, it doesn't matter that then she's taken to a series of slave states. So here again, we find jurists disagreeing with each other about how to think about gradual emancipation statutes. Finally, Southern freedom suits based on Northern gradual emancipation statutes inherently revolved around the extension or rejection of comity, the judicial practice of deferring to another's jurisdiction's laws and legal decisions. Because really at issue in these cases is whether the emancipatory power of Northern gradual emancipation statutes is actually going to be recognized in Southern courts. As Paul Finkelman has shown, comity was widely practiced throughout the United States in cases involving enslaved people at the founding, but began a long decline starting around the 1830s. Now, in light of this broader trend, it is perhaps unsurprising to find a very full-throated defense of comity in one of the earliest of these appellate decisions in cases like this, a case called Violet and William versus Stevens from 1812 in Kentucky. The facts presented in Violet and William versus Stevens are exceptionally spare, but it seems that the plaintiffs in the case were the children of an unnamed woman born in Pennsylvania before the adoption of that state's gradual emancipation law. Sometime thereafter, Violet and William's mother was then removed to Virginia, District of Kentucky. So they were removed to Kentucky, but when Kentucky was still a part of Virginia. And it was there in Kentucky that this unnamed woman gave birth to the plaintiffs. The case revolved around a violation then of Pennsylvania law, and there are one of two possibilities here, either because the plaintiff's mother had never been registered as a slave. The Pennsylvania gradual abolition law is unique in that it not only calls for the eventual emancipation of people born after the statute, it also requires every then enslaved person living in Pennsylvania to be registered according to law. So one of the possible ways there could have been a violation of Pennsylvania law is that this unnamed woman was never registered as the law provided, or there was a violation of Pennsylvania law because this unnamed woman was removed from the state of Pennsylvania without her consent. And that was a part of a 1788 addendum to the original gradual emancipation statute. Regardless of which Pennsylvania law was violated here, when the case eventually went to trial, the fact that the matter was rooted in a Pennsylvania law and not a Kentucky law became a key issue, with the judge of the Fayette County Circuit Court directing the jury that the penalties and forfeitures of a Pennsylvania law cannot be enforced in this state. The Kentucky Court of Appeals, however, overturned the lower court's verdict, and Associate Justice William Owsley insisted upon the necessity of comity. Justice, he basically said, demanded it. He says, to admit the construction given by the circuit court, he observed, would place it in the power of the master at all times to evade the forfeitures of the act and to keep in bondage and slavery those entitled to their freedom. It would only require a coercive transportation to a free state from the state of Pennsylvania to this state to reduce him to a state of abject slavery. Such a construction cannot be recognized by this court. 2 decades later, in 2 other Southern freedom suits based on Northern gradual emancipation statutes, high courts were no longer inclined to give the same passionate defenses of comity. But more importantly, they didn't abandon the practice altogether either. In Virginia, for instance, the defendants in Spots v. Gillespie made an argument that was basically identical to the one presented by their counterparts in Violet and William versus Stevens a generation before. Surely, the defendants in Spots contended, a court in Virginia would not enforce Pennsylvania's gradual emancipation law to the detriment of its own resident. Rather than tackling, however, what had become the increasingly thorny question of comity head-on, the court simply reframed the issue. Court President Francis T. Brooke instead flatly asserted that a conflict of laws, in fact, did not directly occur in the case before them. The court, he said, was not confiscating a Virginian's property by enforcing a Pennsylvania gradual emancipation statute, but instead merely upholding Virginia's own long-standing common law principles, which forbid a free person from being held in slavery. As Brooke tersely asserted, the court is not called on to execute the law of Pennsylvania, but the law of Virginia, which does not now and did not then permit a person free in Pennsylvania to be held here as a slave. It was a rhetorical sleight of hand. By asserting that their judgment was exclusively and firmly rooted in the state's own laws and not the laws of Pennsylvania, the Virginia Court of Appeals could skirt allegations of comity while nevertheless handing down a decision that maintained its spirit. the court could set a person free in the service of asserting its own right to serve as final arbiter of its own law of slavery. Shortly thereafter, in Barrington's v. Logan, an 1834 case from Kentucky, virtually the same move was made. This attempt to disguise comedy as a defense not of laws of another jurisdiction, but of one's own laws. In Southern freedom suits based on Northern gradual emancipation statutes, then, comedy didn't simply disappear in the 1830s, it merely went underground. Southern jurists in such cases didn't stop granting comedy, they simply started denying that that's what they were doing, while continuing to hand down emancipatory decisions that were rooted in a recognition of the freedom Northern gradual emancipation statutes had actually conferred. More than 2 decades after the very last of these appellate decisions was handed down, Thomas R.R. Cobb confidently and I think very glibly proclaimed the precedents that had been established in his 2-volume legal treatise. Where laws have been passed for the gradual abolition of slavery, he intoned, the condition of slaves is changed to a state of servitude or apprenticeship. The issue born during this state are free, he continued, but if a female slave is sold and removed into another state where no such laws exist, issue born after her removal are not free. Cobb was attempting here a neat and tidy description of the law, but he was ignoring the diversity of opinion of Southern judges in such cases on matters ranging from the nature and extent of the changes gradual emancipation statutes wrought on both the children of gradual emancipation and their mothers, as well as issues of citizenship and comedy. In practice, there had actually been a good deal more disagreement over the precise nature of freedom and unfreedom such laws actually conveyed. Thank you.
A difficult act to follow, but one that I think will follow on quite nicely. Just make sure I have my eye on the time. So, in 1833, the Georgia Presbytery at its annual meeting asked a local enslaver, farmer, and for reasons I'm not entirely clear on, local Baptist, he was not in fact a Presbyterian, Thomas Savage Clay, to speak on the question, what is the best mode of improving the moral condition of our Negroes? And Clay's answer was, at least in part, solitary confinement. He published his remarks in a small treatise called Detail of a Plan for the Moral Improvement of Negroes on Plantations, which was a scheme for realizing the enslaver's recurring fantasy of the slave who is grateful for their enslavement, who obeys because that is their sense of what virtue demands, and who is a Christian whose faith extends no further than Colossians 3:22. Servants, obey in all things your masters according to the flesh, not with eye service as men pleasers, but in singleness of heart, fearing God. And in Detail of a Plan, Clay elaborated a program for doing just this, including preaching, temperance societies, and what he called a well-arranged and regularly enforced system of plantation discipline. He endorsed solitary confinement, whose effectiveness, quote, in reforming the depraved and awakening a moral sense in the degraded, have been fully proved in our modern penitentiaries. So much so that, quote, every slaveholder who may have it in his power should visit a penitentiary managed according to the Auburn system. He will there learn the best methods of reforming the vicious, controlling the unruly, and making the idle industrious. Now, reforming the vicious, controlling the unruly, and making the idle industrious summarizes the project of the penitentiary far more pithily than most of its ideologues ever managed. And the program that Clay elaborates in this vicious text resembles nothing so much as a penitentiary mapped on to the plantation, a spatial, human, administrative, and violent project for the reformation of individuals and the coordination of their movements in good Foucauldian fashion. And while Clay's enthusiasm for the penitentiary was perhaps unusual for a Southerner, at least in his vocal endorsement of it, the influence of contemporary penal reform, of that other great institution of unfreedom in the 19th century, the penitentiary, on the theories and practices of violence and discipline in the plantation has been chronically understated by scholars. What I am struck by above all is how often the phrase solitary confinement appears from the pens of enslavers from the Cape Colony to Canada, from the Pacific to the Indian Ocean, from both the enslaver and the enslaved. And I want to take that terminology seriously. This is not a random conjoining of words. Solitary confinement in the 19th century is a term to conjure with. It is the great key word of prison reform and institutional reform more broadly. And it is a term, I want to put it to you, that both enslavers and enslaved knew what they were doing when they mobilized it to discuss, to contest, and to resist what slavery was doing. The currency of that term, I argue, reflects what one literary scholar has called the deep interconnection between slavery and Enlightenment penal practices. We might recall Toni Morrison's brilliant observation that we should not be surprised that the Enlightenment could accommodate slavery. We should have been surprised if it had not. So Clay himself may have visited a penitentiary. I suspect he probably did. He certainly traveled a great deal in the North, had family in the North, was educated in the North, but he didn't need to, because the institution was making great inroads across the South and West. Georgia, for example, his home state, had had a penitentiary for the better part of 2 decades. Since 1817, the penitentiary at Milledgeville had been operational. And across the Atlantic world, slave societies were no more immune than non-slave societies to the fever of prison building and prison reform that what we tend to think of as the penitentiary movement, this new vision of a redemptive and reformative prison administration and prison architecture, was causing, most notably in Great Britain and in the northern states of the Union. At the same time, as the formerly enslaved Charles Thompson recalled, there were, quote, slave jails in nearly all the villages of the South. These were just so many outposts of a network of power that took the violence and the control of individual enslavers and formed a great web, what Walter Johnson has brilliantly called the carceral landscape, that held the enslaved captive on individual plantations and within the unfree Atlantic. One enslaver, for example, Charles Manigault of Louisiana, knew this very well. Of Georgia. In 1847, he wrote a series of instructions to his overseer on, quote, how to make an example of those individuals unbroken by the ordinary tortures of the plantation. Quote, take him with you down to the Savannah jail and give him prison discipline and by all means solitary confinement for 3 weeks, when he will be glad to get home again. Both law and custom across the Caribbean, across the United States, and beyond conferred just such a prerogative on enslavers. In New Orleans in the 1830s, according to one traveler, nothing was more common than the use of private and public jails as an instrument of private discipline by enslavers. 2 decades later, the Louisiana enslaver, St. John Richardson Liddell, was taken aback and not best pleased to learn that, quote, they will not take Negroes at the penitentiary unless they are convicts, though he had hopes that he would be able to find room at the state prison in Jackson, Mississippi. But one of the key points as we think today about institutions that I want to suggest is we can't reduce institutions to the brick and mortar penitentiaries, for example, that were cropping up across the Atlantic world. That the many brick and mortar penitentiaries were far outnumbered by the many ink and paper ones. In the innumerable texts, reports, treatises, dialogues, novels, and general legislation circulating in 19th century print. And they found avid readers among enslavers who borrowed the language, the concepts, and indeed the practices of penal reform to reform, to enlighten, if you'll pardon the irony, their own institutions of confinement and carceral violence. Diana Patton, for example, has shown that the reforms in the mid-19th century to incarceration in Jamaica borrowed prison reform's emphasis on, for example, new and purpose-built spaces of confinement, competent staff, regular inspection, the classification of inmates, and a concern with moral contagion. The hallmarks, for example, of just how widely spread this sense of institutional discipline across and between these institutions is perhaps encapsulated by Nicholas Herbmont, who was an agricultural reformer, a slave reformer, and the first head of South Carolina's insane asylum. And he wrote about the impact of solitary confinement. Man, though in a state of ignorance, has some activity of mind as well as of body. Curb it, and you render the individual miserable. The result is that, quote, solitary confinement is the most severe punishment short of death. Again, the ideologues of Eastern State Penitentiary or Millbank in Great Britain could have done no better in enunciating the theory of solitary confinement in the 19th century and why it became, as I argue, the cornerstone of prison reform. This theory bled very much, and bled is unfortunately the word, into the practice of actual plantations. To give one perhaps anomalous example, but an interesting one, the British-born philosopher Frances Wright, when she was traveling through the United States in the 1820s, wrote in her travelogue that solitary confinement had been shown, quote, by experience to be a sentence more dreadful and more dreaded than death. In the prisons of these states, and she was thinking particularly of Pennsylvania and New York, it has subdued the most hardened profligates and inflicted mental agonies which they would gladly have exchanged for the transitory horrors of the scaffold. 5 years later, when Wright had herself become an enslaver and was operating the Nashoba project, which she hoped would sort of gradually abolish slavery, she was tasking herself with the reform of about a dozen enslaved men and women. And writing to an abolitionist newspaper, she boasted that in the months she had been leading the project, there had only been one instance of resort to punishment for theft, malice, and obduracy. And the woman in question, who the philosopher had herself purchased from a slave market in Nashville, quote, we had recourse to solitary confinement and a diet of bread and water. In 24 hours, her obduracy gave way, and we were able to release her. Wright does not tell us where she confined this prisoner, but her fellow enslavers built private jails, co-opted local, state, and even federal prisons, and exploited any space where a human being might be enclosed, from cabins to cellars to cotton gins to barns to stables to even closets and cisterns. Enslavers like Wright shared with the penitentiary a set of ideas about reform. They were keenly interested in molding the interior lives of those they held prisoner. Clay echoes, again, the language of the penitentiary movement in declaiming, should the fear of punishment alone deter the slave from stealing, he would still be destitute of the principle of honesty, of that which constitutes a moral trait in his forbearance to take what belongs to another. A much more unenlightened enslaver, William Trotter of Mississippi, still used the language of reform, using solitary confinement in the plantation jail that he gives his readers advice on how to build, to punish those who absconded from the plantation, quote, until he reforms. And again, I want to pay attention to the language that enslavers and their propagandists are using in this period. The fact that they talk so often about reform is worthy of our notice. The fact that they are intensely interested in what they would describe as the morality of the people they are confining and exploiting and torturing is a fact worthy of our notice. And we have to think more capaciously than we have done about what reform would have meant in the language of a mixed free and slave society, or rather an entirely slave society in which not everyone was enslaved, and how we have to complicate what a notion like reform means as a result. And so to conclude, the long-standing division of the history of the 19th century institutions of unfreedom into a dichotomy, or occasionally a trichotomy, plantation, penitentiary, and sometimes reservation, has to be qualified. We can no longer hold, as Adam J. Hirsch once wrote, quote, "No slaveholder could have found solace in a penitentiary's advocate to instill in persons a habit of industry, let alone a reclaimed conscience." That is precisely what enslavers hoped solitary confinement would do, applied on the plantation. Solitary confinement, the medium of the penitentiary's great hopes of a coerced redemption, held out what Trotter called punishment that will effect a reformation. And indeed, the enslaved themselves described incarceration on the plantation as a process of making new kinds of people and eliciting new kinds of behavior. In Mary Young's experience, for example, 3 days of starvation rations in the enslaver's jail, quote, "would make good Negro out most slaves." As Sadia Hartman has taught us, the heart, the soul, and the mind were simply the inroads of discipline. The recognition of humanity and individuality acted to tether, bind, and oppress. And I will conclude there simply with the words of William Walker, having begun with one person who moved between the world of the plantation and the world of the penitentiary. I'll end with another. William Walker was born into slavery in Virginia in 1819 or 1820, lived into the 1890s, spent many years in enslavers' jails and in plantations across the South, got free, got to Michigan, where he spent a life sentence in the state penitentiary at Jackson State, and wrote a book called Buried Alive, his part slave narrative, part prison memoir, in which he critiqued solitary confinement as the worst kind of living death, and the penitentiary as a more severe and systematic style of torture than was ever heard of on Southern soil. Clay and Walker both recognized in solitary confinement a bridge between these two towering institutions of 19th century unfreedom, but only Walker understood what he saw. Thank you very much indeed.
Pull up a slideshow here. Yeah, there we go.
I think we do need to switch the input.
No, I think it's okay.
Oh, okay,
There
good.
we go.
Sure.
There we go. Not the most tech-savvy person I am. Good morning. My talk today is, there we go. My talk today is drawn from a couple of chapters of my forthcoming book, Houses of Pain, Domestic Violence and Legal Intervention in the United States, 1870 to 1994. The book covers more than a century of American history, so while my talk is going to focus on chapter 5, gender anxiety, the medicalization of violence, and the decline of paternalism in the mid-20th century, I'll start by describing the overarching thesis and contributions of the book, and set the scene for the discussion of the 1950s and 1960s by first presenting my findings about how domestic violence was treated earlier in the late 1800s and early 1900s. My book revises a standard feminist narrative that non-intervention in intimate partner violence constituted a static feature of the patriarchal state. Conventional feminist accounts typically assert that women were beaten by men and killed by men with the men's impunity, but treated women's violence as depraved and subversive. According to Reva Siegel, official endorsement of men's right to inflict corporal punishment on women was replaced by deference to marital privacy, but that still constituted a policy of non-intervention. My book shows instead that state intervention in the family, including criminal sanctions against wife beaters and wife killers of all races and social ranks, preceded the battered women's movement by at least 100 years. One of the contributions of the book is to provide a new periodization of the state's response to intimate partner violence that shows pendulum-like swings in the level and type of intervention. From a paternalistic approach in the late 1800s and early 1900s to marital conciliation, the medicalization of violence, and arrest avoidance in the mid-20th century, and finally to the aggressive policy of arrest and no-drop prosecution spurred by second-wave feminists in the late 1970s, 1980s, and 1990s. During the period I call the long 19th century, the Victorian ideal of companionate marriage prescribed conduct for men and women. Husbands were supposed to serve as protectors and providers, while wives kept the moral compass, raising children and also exercising a civilizing influence on their husbands. Even as progressive ideology prompted government reform, including a reorganization of courts, men continued to be subject to the standard of the sober, self-controlled breadwinner. Hence, violence against women, the so-called weaker vessels, aroused social condemnation and criminal prosecution. This imperfect system treated domestic violence as a crime because of its deviance from standards of manly conduct that were idealized in that time period. In short, legal intervention in intimate relationships during the late 1800s and early 1900s had very little to do with gender equality. And I hope the book participates in conversations not only about feminist theory and criminal justice, but also about masculinities. While many scholars acknowledge that wife beating was formally criminalized by the 1870s, the conventional narrative assumes that the law was not enforced. In fact, the records of low-level courts called police courts or city justice courts demonstrate the routine arrest or summons of men before magistrates on charges of assault and battery, making threats, and disturbance of the peace against their wives or girlfriends. Misdemeanor sentences in the late 1800s and early 1900s involved fines or imprisonment. The $50 fine or 50 days in jail for George Ballard in San Francisco in 1906 was actually on the lenient end of the spectrum. The state construed domestic violence cases as being brought by the people against deviant men. By the second half of the 19th century, these were not private prosecutions. Yet fear and socioeconomic dependence led women to beg for non-carceral punishments or the dismissal of charges against their husbands. In the Toll case, for example, in Los Angeles, the court imposed a 5-year prison term on Frank Toll for assault with intent to murder his wife, but she wrote to the California governor and pleaded for his release from San Quentin. Another element of conventional histories is the claim that although some domestic assaults and homicides were prosecuted, there was little or no punishment for anyone but poor and racial minority defendants. Again, my research modifies the received wisdom. Rich, socially prominent men like millionaire mining baron Griffith J. Griffith got sent to prison for felony offenses and at least fined for misdemeanors. Affluence didn't prevent men from being considered brutal, intemperate, and disreputable. In fact, punishing a few bad apples bolstered the perceived legitimacy of the whole system. Men charged with murdering their wives or girlfriends found that the provocation doctrine was applied narrowly, leading to murder convictions, life sentences, and even the gallows. Wealth enabled defendants to pay high-caliber lawyers and expert witnesses, but it didn't ensure acquittal or mitigation. Nevertheless, the majority of convicted wife murderers came from the ranks of the working class and the unemployed. In short, the first several chapters of my book show that legal intervention in domestic violence primarily amounted to the censure and criminal prosecution of men in a way that reinforced hierarchy by legitimating a status quo based on the performance of respectability. This approach was ineffective to prevent intimate partner violence because aside from expanding the grounds for divorce, the state offered no structural solutions, no safety net to help beaten women navigate leaving or repairing a violent relationship, especially if children were involved. Even though divorce was becoming more accessible, it still meant social stigma and financial precarity, not to mention the grave danger of separation assault or even separation homicide if the woman tried to leave. So many victims, like Marianne Toll, declined to assist the prosecution, which sometimes led to dismissed charges or lesser offense convictions, as well as to public debate about which types of punishment, whipping, suspended sentences, hard labor would be best for wife beaters. Some frustrated judges actually held women in contempt of court for refusing to testify and jailed batterers over the objection of their victims. Violent husbands commonly reoffended despite these encounters with the criminal law. A corollary, a really remarkable corollary of this situation, I think, was that during the long 19th century, homicide became a tacitly accepted form of self-help for women in their abusive intimate relationships. Fact finders recognized abused women's entrapment in intimate relationships and declined to convict them of murder, and in a lot of cases, even of manslaughter. Women accused of intimate homicide succeeded to a remarkable degree in making self-defense arguments. Moreover, wronged women narratives, sometimes referred to as the unwritten law defense, also justified the killing of unfaithful husbands and lovers who reneged on promises of marriage. Even temporary insanity verdicts in such cases were suffused with moral judgments against the deceased men. Now, we can talk in the Q&A about the extent to which this was true of cases of women of color, working class women, or white women who had a reputation for sexual promiscuity or drunkenness. They did have a harder time attracting sympathy. My findings are not limited to California. Each chapter of the book offers examples from other parts of the United States. For example, Chicago was especially well known for the acquittal of husband killers. So what changed and when? Despite the ratification of the 19th Amendment and superficial changes in fashion, the response to intimate partner violence during the Roaring 20s demonstrated the persistence of essentially Victorian values and modes of justice. Neither the Great Depression nor World War II permanently disrupted the traditional gender-based division of labor. In the interwar period, domestic violence cases still resulted in more severe outcomes for men than they did for women who were accused of similar offenses. Those subtle shifts did occur, which I'd be happy to discuss in the Q&A. My book identifies the late 1940s through the 1960s as a period of social change that really spelled the end of paternalistic approaches to domestic violence. The baby boom concept of family togetherness supplanted the last vestiges of the Victorian domestic ideology, which had been under attack from a variety of angles, including liberal and anti-maternalist critiques. Rather than simply constituting a reassertion of traditional values, the baby boom ideal sported a shiny new veneer of liberal individualism. Women were encouraged to stay home with young children and derive personal benefit from homemaking, rather than claim moral motherhood as a civic virtue and patriotic duty. But family togetherness cloaked new tensions and a devaluation of mothers. The idealized Victorian matron had been replaced by plain old meddling mom, who was neither entitled to claim special privileges nor compete directly with men. Appetite for consumer goods and services, as well as greater independence, meant that an increasing number of middle-class wives went out to work once the kids started school. But while Dr. Spock urged fathers to change a few diapers and participate in family activities, women remained less than equal in their marriages. My book chapter on mid-century America emphasizes 4 developments that affected how domestic violence was treated. First, starting in the late 1940s, the media popularized psychoanalytic theories, which posited that women were complicit subconsciously in their own abuse. Several researchers even claimed that domestic violence could help a couple achieve a working equilibrium. Episodes of intoxicated violence by the husband supposedly gave him a release momentarily from his anxiety about his ineffectiveness as a man, so he could maintain a good job, a nice home, and an outwardly stable family. Reciprocally, being beaten supposedly satisfied the masochistic impulses of the domineering wife. The husband's drinking aided this role alternation. The absorption of such ideas into mainstream culture affected law enforcers' responses to domestic violence, as I'll explain in a minute. Second, therapeutic efforts to discourage divorce, exemplified in California by the Los Angeles County Conciliation Court, influenced not only family law, but also criminal justice. In an effort to turn the tide of divorce, the judiciary promoted marital reconciliation as essential to children's well-being. Although pre-divorce courts had existed before World War II in several cities, the heyday of therapeutic efforts to heal marriages occurred in the 1950s and 1960s. For example, the Los Angeles County Conciliation Court was actually established by enabling legislation in 1939, but it didn't achieve prominence until it came under the leadership of Judge Louis Berg, who in the 1950s hired professional marriage counselors and pioneered the husband-wife agreement, which was filed as a court order and could be enforced through contempt proceedings. The model agreement discouraged physical violence, but it also advised wives to end their employment and devote themselves to cooking, house cleaning, and childcare. The agreement supposedly embodied techniques in keeping with the most advanced thinking in the psychiatric field. Domestic relations courts had long had authority to punish spouses for non-support, so the coercive aspects of the conciliation court weren't exactly unprecedented, but its therapeutic approach to diseased marriages spilled over into the handling of criminal dockets. Ordinary municipal judges still had criminal jurisdiction over simple assault and battery, while superior courts continued to handle felony offenses. As late as 1945, the California legislature enacted a gender-specific wife-beating statute that made wife-beating a felony. But the attitudes of police, prosecutors, judges, and even the general public had gradually changed. From the perspective of law enforcement in the 1950s and 60s, domestic violence calls were a tremendous waste of manpower. Officers saw themselves performing a role more akin to a chaplain than a law enforcer. Their homespun counseling was underpinned by the belief that a wife's apologetic explanation that she needed a good beating could be taken at face value. The SFPD forbade the rank-and-file cop from making arrests in so-called family or neighborhood controversies without permission of his commanding officer. And a special family relations bureau in the San Francisco DA's office that was run by social workers instead of prosecutors now handled misdemeanor domestic violence to reduce costs and lighten prosecutors' caseloads. So it was this mid-century approach, reflecting trivialization and excuses for domestic violence against women, that second-wave feminists challenged, though they associated it with meta-historical male domination. Mid-century legal doctrines kept pace with changing social values and developments in psychology and psychiatry, producing a series of reforms that included the adoption of the diminished capacity defense by a substantial minority of states, the expansion of the provocation doctrine, and the addition of a volitional incapacity prong to the otherwise cognitive insanity test. The vote for psychological determinism influenced domestic violence cases in the 1950s and 1960s. This slide uses California law to illustrate that defense counsel now had a handful of expanded theories at their disposal to excuse homicidal violence in intimate relationships. The inclusion of intoxication, along with mental illnesses like schizophrenia, as a form of diminished capacity was especially noteworthy because it showed that drunkenness now attracted compassion as disease rather than being condemned as moral vice. The medicalization of violence had two major effects worth underscoring here. First, the expansion of excuses for intimate femicide, especially reformed interpretations of voluntary manslaughter, operated as a downward ratchet, providing mercy to male defendants whose emotions simmered for a long period of time or were sparked by highly individualized triggers. That much is well known, Victorian Norse, right? But second, new ways of thinking about criminal responsibility acted as an upward ratchet for female defendants whose acquittal would have been almost assured in previous decades. As long as women accepted their exclusion from power, verdicts in criminal cases remained tethered to gendered moral scripts and depended relatively little on black letter law. But in post-war America, women grew increasingly dissatisfied with their isolated wife-mother role. By the mid-70s, more than 40% of wives worked outside the home. Formal equality principles, as well as backlash, reduced the appeal of narratives that had spared female defendants in the past. An honest, reasonable wife could just file for divorce and get a job if she needed to escape abuse, prosecutors now explained in their closing arguments. Two cases, those of Rose Lucas and June Ferber, exemplify the frying pan or fire dilemma that battered women faced around mid-century. Rose Lucas claimed at her murder trial that she shot her husband Joe, a California state highway patrolman, in self-defense with his own service revolver after enduring years of beating, choking, and death threats. In December 1956, police responded to a domestic disturbance call at the Lucas home. During their 5-minute investigation, the officers quote-unquote patched up the family quarrel and told Rose she could pursue a complaint at the district attorney's office. But less than a half hour after the police left, without arresting Joe or confiscating his weapon, Rose killed him. She claimed that he lunged toward her, having resumed his death threats as soon as the officers departed. Although the jury ultimately found Rose guilty of manslaughter, voluntary manslaughter, instead of murder, she still faced 1 to 10 years behind bars. The prosecutor had told jurors to acquit this defendant as to give every married person in San Francisco a license to kill. The why didn't she leave question that loomed in Rose's case was relatively new. Unlike Rose Lucas, June Ferber decided to leave her abuser. Her case thus embodied another facet of the exit myth predominant in the second half of the 20th century, the myth that divorce provided an easy escape from an abusive marriage. In 1961, June divorced her husband, Michael Chingoon, because of his repeated physical assaults on her. She resumed her maiden name, Ferber, and tried to make it on her own by doing secretarial work. Her ex-husband continued to harass her after their marriage ended, though. His misconduct included attempted battery, numerous death threats, and the killing of Ferber's dog, all of which courts described as non-physical activity, defining physical very much as an actual act of violence, contact in the body. Ferber was so afraid of Chingoon that she slept with a meat cleaver for protection and purchased a .38 caliber gun in March 1964. In April 1964, Ferber's ex-husband arrived at her apartment in San Francisco. He had a legal right to be there to pick up the kids for visitation, but the custody order barred him from entering the apartment. June opened the door, but when she saw her former husband outside, she went back and got her gun. She claimed he pounded on the door and then gave her a look that terrified her, so she shot him to death with the pistol. Both June and Rose were initially convicted of voluntary manslaughter. After an appellate court reversed June's conviction due to police misconduct, she pleaded guilty to involuntary manslaughter and got time served plus probation. Yet despite the milder outcome, June Ferber's case showed that using deadly force as self-help when divorce failed to end domestic violence didn't satisfy mid-20th century judges or jurors any more than the stubborn marriage-mindedness of Rose Lucas. The diminished traction of battered women's rational self-defense arguments led to reliance on insanity theories and more often guilty pleas to manslaughter. So I'll just leave you with a slide from the next chapter of my book showing data from the 1970s. And you can say by the mid-1970s, manslaughter pleas overwhelmingly predominated in women's cases. So they had gone from the sort of chivalrous acknowledgement of their entrapment in social norms, which produced sympathetic acquittals, to an overwhelming likelihood that they would serve some time behind bars for killing an abuser. Thank you.
Okay, well, thanks to all three of you for these fascinating papers. I'm glad to be here commenting on this panel on topics including slavery, incarceration, gendered violence. I am expert on precisely none of those topics, so I hope you will take my comments here with the appropriate grain of salt. Let me start with Anne Twitty's paper, which explores the topic that I'd say I'm most familiar with. So as Twitty discusses, there is an extensive literature on jurisdictional conflicts among the states caused by the patchwork of laws governing chattel slavery and on the legal ambiguities established by gradual emancipation. But my sense of the literature is that by and large, this work has largely been focused on the North and on border states, actually like Twitty's own prior book on Missouri. Southern jurists, I think the literature has usually presumed were united in their desire to protect slavery, and those of us who teach legal history know that often the standard text that gets assigned is state versus man, which sort of suggests precisely this vision. But as Twitty persuasively shows in this paper, Southern jurists were just as plagued by these uncertainties as their Northern colleagues, because they too had to grapple with these difficult problems of conflict of laws. And as I think she astutely notes, right, even if they were results-oriented in the sense that they wanted to protect slavery, it was not always clear, sort of ex ante, which rule would further that result. So I found a lot in this paper persuasive and actually somewhat familiar from some of my own work on landed property. There was often a similar challenge of trying to make sense of ownership claims, where you have sort of interjurisdictional conflict, and often in the context of land, it was because literally the jurisdiction had shifted where the land was located, as opposed to, in this instance, where you have the horrors of ownership of people, where the property is being moved from one jurisdiction to another. But it did leave me with a few questions. First, Twitty, I think, convincingly shows us that Southern judges were just as confused by the problems of conflicts of laws as judges elsewhere. So I guess the question is, what does this tell us about regionalism and the distinctivist or not of Southern law during this period? In other words, does the fact that they are grappling with these same problems point to sort of a national legal order that they're all working through, or is there something distinctively Southern about the way they are working through these particular problems? Similarly, and actually inspired by Twitty's prior work on Missouri, I was struck by a lot of the fact that the litigation is happening in border states or border-ish states like Virginia and Kentucky. And I was just curious, is this just a reflection of the patterns of the domestic trade in enslaved people, or is there something about these jurisdictions that makes them distinctive from, you know, the Alabama, Mississippi, even places like North Carolina? And finally, the paper describes a drop-off in the disputes when you get into the 1830s and 1840s. One explanation of this is just in some ways a similar echo of the process you see in the North, where gradual emancipation import declines over time. But it is also interesting that this is also the precise moment when you see the rise of the sort of Finkelman comity fights, where all of a sudden the questions about whether one state will honor the laws of another state concerning enslaved people sort of become much more pressing. Okay. Let me turn to Spencer Weinreich's paper, which, as we heard, examined the widespread use of solitary confinement and the rhetoric reform in the context of chattel slavery. There were a number of things that in this paper that surprised me. One, quite frankly, was the consistency in terminology. The fact that, you know, penitentiary to us now, I think, has a sort of old-fashioned ring, but solitary confinement has interestingly remained constant as sort of this term of art. I find that really strikingly rare and quite noteworthy. And the other thing, which of course is what his paper emphasizes, is how many of these enslavers were students, observers, and maybe acolytes of the sort of rise of reform and the penitentiary movement. So I gather this is an excerpt from this larger project, and as I understand, part of this is to show, as you pointed out in the paper, right, how entangled the history of incarceration and the history of slavery, in fact, were. But I did wonder a little bit about thinking about this in the context of the historiography of slavery as it is currently framed. For those of you who are the grad students here, I'm going to draw on my dimly remembered exam prep, so it does have some value here. But when I think about the portrayals, the current literature on slavery and capitalism tends to focus not on the if we think of this Foucauldian sense of the dichotomy between spectacular violence and the more intimate violence of the penitentiary, the slavery and capitalism literature emphasizes just how much spectacular violence was present in slavery. In fact, that was sort of often is presented as the rational economic choice that is being made to extract labor. And quite frankly, there's little interest in the enslaved become not in fact people in this sense, but merely sort of parts of this mechanism of production. And so what's striking here is the way that we have enslavers embracing this reform-minded ameliorative vision, at least as the reformers proposed it in places like Eastern state. And so I'm curious, do you think that there is a tension there in your account and their account? I think and also the fact that so many of the other question I had was also, does the trade gap go the other way? In other words, much of this is about the consumption of Northern reformers' visions by Southern enslavers. I met, many of the reformers or self-styled reformers saw themselves as opponents of the enslavers, right? And many of them came subsequently to embrace abolition. So I'm curious if there is a similar, what the trade gap looks like in the other direction. How the penitentiary reformers are envisioning their institution in light of the other institution of unfreedom, as you pointed out. Okay. Finally, turning to Carolyn Ramsey's presentation, here too, actually, I found my sense of conventional wisdom being uprooted. I think, without realizing it, I had absorbed the sort of standard feminist narrative that intimate partner violence was largely tolerated prior to the advent of second wave feminism. And so your account is so much more nuanced and gets at these sort of very interesting unintended consequences that show much more of a up and down trajectory over the course of the 20th century. So here, and maybe because we're in the 20th century, and for someone who does early American history like I do, the 20th century is basically the present. I'm going to be presentist for a moment and say that this account sort of made me reconsider some of the debates that we've been having about what gets described somewhat usually pejoratively as carceral feminism. So shortly after, actually, I arrived here at Stanford. We had the Brock-Turner case, which was very much framed around, the discourse was framed in these conventional terms about, the criminal justice system letting off, or people who are skeptical about the criminal justice system versus those who thought that, the criminal justice system was not being harsh enough on people who committed gendered violence. But what's striking, and here in particular in the chapter, I was struck by the fact you emphasize many of the reforms are not gendered in their intent, right? The effort to create sort of diminished capacity was actually sort of inspired by this psychological movement. Nonetheless, ends up having this profoundly gendered impact, such that intimate partner violence committed by women was punished, but male intimate partner violence often went unpunished. So I guess what's striking about your story is how many ironies and unintended consequences there are, which I think is, of course, precisely what good history captures. But I'm curious how that reframes. I mean, you do all this teaching and writing in current debates about criminal law. How this reframes how we think about the current moment and discussion we are having about the remedies here. Because what's striking is that both pro-defendant policies end up adversely impacting female defendants. But by the same version, the law and order policies that are then advocated by the second wave feminists as a way to remedy this inaction also ends up having this profoundly disparate impact. And so it leaves us in a place where, the impulses, these competing views that come out of these cases, both of them don't seem to necessarily offer a path forward. So I'm just curious to how you think about these debates in light of this history. So these papers despite being disparate in time periods and topics, for me, what John put together is they all really challenge what I thought of as my sense of the conventional scholarly wisdom and forced me to re-examine these narratives that I had either consciously or unconsciously absorbed from the literature. So this is precisely, I think, what good scholarship should do. So I'm really excited to thank all three presenters for really making me think harder and deeper about these questions. So with that, I'll turn it over to questions. Can you remind me when do we are supposed to stop?
So our next panel technically starts at 10:30, but I think we'll make it happen if we have like 10-ish minutes.
Okay.
We'll make it work.
Great. 10 minutes for those of you who have questions for our panelists.
So I have a question for Carolyn.
Mm-hmm.
So when I'm thinking about the long 19th century and Reva Seagull's work and things like that, the way I think of that is that when you get punishments for abusive men, husbands, but they're really quite special in certain ways. Like they're often targeted at men of the lower classes who are not bearing up to the responsibilities of masculinity, but also, and to the extent that they involve people who are more genteel, they're really only the most egregious kinds of things, like really hurting the spouse in some way that's really very apparent battering, or killing, right, or attempted killing, and that the courts are still very reluctant to look inside households at lesser kinds of or lesser levels of abuse if those households are genteel. Does that seem right to you, or?
No, I think that's what I'm debating, and that is that if you, it's certainly true that the extreme cases were prosecuted. So Griffith actually shot his wife and destroyed her jaw. That was a very serious case. So in that sense, it's not surprising that he was sent to prison. But if you look at these lower level courts, if you can look at the dockets, and men were brought in for hitting the wife, or shoving the wife.
Classmen, or do you
it's a variety of things. It was predominantly lower class, but I think one thing that I challenge in the book about the Victorian ideology is that I don't think it was completely class bound, because men in the working class wanted to perform respectability so that they seemed, it raised them a bit in society. And so I think what you see is men policing other men, and it's not simply a matter of the elites or the middle class policing the lower class. There were plenty of instances of neighbors calling for the police because someone next door was beating his wife. One thing that didn't get involved in my talk was the extent to which in the 19th century there was mob justice. There were actual rough ridings of wife beaters that still happened in the 19th century. The tar and feathering, that kind of thing. So I think that this really crisp divide between the middle class and plebeian attitudes towards domestic violence, I think, is a false one. In part, and here I'm kind of borrowing from masculinity's theory, is that lower class men were trying to show their superiority to brutal, drunken lower class men who were beating their wives. So I do find the previous work in this area oversimplified. Reva's work is subtle and interesting. She's not really talking about a completely static situation, because she's talking about preservation through transformation. There's certainly a lot of more simplistic work that's gone on, particularly, I don't want to point fingers, but like in legal scholarship, there's a lot of just kind of that introductory first paragraph that says nothing has been done about wife abuse for centuries until the 1970s. And so I'm trying to problematize it on a variety of levels of sophistication. But it is really interesting to look at these lower level cases as well as the more high profile ones.
Molly?
Thank you for 3 really interesting papers. A question for Spencer, which I think maybe was one of your questions. I'm not entirely sure. The
papers you presented or the book really focuses, at least as you give it to us here, on the ways in which the idea of solitary confinement from the penitentiary kind of bleeds into the plantation system. At least that seemed like the trajectory. Wondering, maybe I think this is what you meant by trade back, like what were penitentiary reformers saying, thinking about plantation systems?
So this is actually just one chapter. The book is a sort of broader history of solitary confinement, but the other way round, this actually maybe also answers one of Greg's other questions about the slavery and capitalism literature and the ways that it is taking a different view of what the violence of the plantation is meant to accomplish. Part of this is, I think, that literature is looking at one vision of solitary confinement. The Auburn vision of solitary confinement, that is the one that Clay actually endorses, is a lot less interested in working this kind of deep internal transformation than it is in exterior virtue, obedience, and industry. And they do, some of the ideologues, particularly of Auburn, talk a lot about slavery. The critics of Auburn talk about slavery all the time. Because one of the things that's most controversial about Auburn and the kind of total monopoly it basically wins over how penitentiaries are run is that they use the whip as well as solitary confinement. And so they are constantly being compared to plantations. Though the more common way of configuring it is, as Greg said, that a number of the big prison reformers are also eventually abolitionists. One of the exceptions that I just want to flag is those of you who have read Harriet Jacobs's brilliant Incidents in the Life of a Slave Girl written by herself, Dr. Flint, James Norcom, her enslaver, was a student of Benjamin Rush, the great intellectual architect of the penitentiary. So it does go both ways. It's just a matter of kind of which vision of solitary confinement they're using. And one of the arguments of my book is that we can't just think of solitary confinement as this very moralized about redeeming the individual, even in the days of the penitentiary. That solitary confinement is a form of violence and a really effective form of violence. And that's where I would actually say I agree with the slavery and capitalism literature. It's just that there's a lot of ways to brutalize people into working that don't involve a whip or a stick.
Jared.
Thank you all. My questions are for Anne. I have one about the jurists and one about the slave plaintiffs. I was wondering, are these jurists, when they're confronting these issues of a first impression, how much are they reaching for Roman law and the law of nations as opposed to, domestic traditions? That would be really an interesting thing to see because it's such a contested category. And I was also just wondering how these suits are generated.
Yeah.
How do the enslaved plaintiffs find representation? I would imagine that when they're purchased, the buyers probably often don't know about their questionable status, almost like a kind of a title defect. And is there cross litigation to the seller, for this kind of thing? Just how a case like this arises would be really interesting to hear.
Yeah, so as far as I know, and there's a relatively sort of small number of these appellate decisions, there's a few more sort of local level cases. Trying to find these types of freedom suits in particular is a little needle in a haystack because the set of circumstances that I'm after, people who are subject to gradual emancipation statutes, but who are sold south, sometimes the petitions are not as descriptive as you would like. Some of the details of the cases aren't as descriptive. And so you can have a hard time trying to figure out if this is an individual who's been kidnapped into slavery or someone who's simply been trafficked from the north into the south. There's only one case, one of these appellate level decisions that talks about Roman law or international law in any way whatsoever. And that is that case, Amy v. Smith, a really, really long one. And actually, what it's interested in is Roman conceptions of citizenship, right? This is the case that delves into the subject of citizenship. Who is a citizen? As I suggested, the details of Amy V. Smith are really complicated and convoluted. She is in a lot of different jurisdictions, and what her case actually ends up hinging on is more narrow and technical. But this is the one place in which, you have these jurists really kind of trying to think about these Black people and the long history of sort of like, what is citizenship? Who can be a citizen, right? And what do we know about that from history? Otherwise, a lot of these decisions are relatively narrow in terms. I mean, they're not particularly long in most instances, and they are framed around, the domestic institution of slavery. There is huge variability, and to some extent, I think this maybe gets at some of the questions that Greg was asking about why we have cases where we have them. Some of this is directly related to jurisdictions that are very close, in particular to Pennsylvania. So you've got a lot of Virginia and Kentucky cases, because actually, just like in Greg's work, there's a corner of Pennsylvania that is disputed between Kentucky and Pennsylvania, and so there is a question of sort of which jurisdiction actually sort of applies in the early years after gradual emancipation has been adopted, and there's disputes that grow out of that. There are at least enough freedom suits like this in Kentucky that eventually the Kentucky legislature will pass a bill basically saying there's a statute of limitations for people seeking redress, people who are subject to gradual emancipation laws in Pennsylvania who then are moved to Kentucky only have a certain period of time to file a freedom suit. Unfortunately, a lot of the Kentucky, the lower level circuit court cases are destroyed during the Civil War, so there's a lot of missing records, but we know that it was enough of a problem that the legislature decided to address it in this particular way. There are a few more sort of deep South cases, but I think have this kind of and there's all kinds of reason to believe that there were lots of these people who would have been trafficked to the Deep South. The big slave trading ring that we know about that involved a number of New Jersey slaves, for instance, they're taken to New Jersey or they're taken to Louisiana and Mississippi. So I know that there kind of should be sort of more where so far I've found a void. It varies tremendously from place to place, how much access I think these individuals have to the legal system. So that I think that's also part of the answer to, we find weird pockets of these cases in certain places, and then there aren't any where we know that there kind of should be some, or we think that there probably should be some. And I think a lot of what you're seeing manifest there is maybe these people live on a plantation somewhere and they're not in an urban setting where they have relatively easy access to attorney or legal advice or other individuals who might have information about how the law kind of works in this particular way. So there's a lot of unevenness, and this is fundamentally what I'm looking for is it's an illicit activity. It's trafficking people who should have remained in the North according to these gradual emancipation statutes. So I think that is the last little bit here that's really kind of complicating why we find things where we do and why they aren't in other places. And I'm still actively on the hunt for additional cases that this is and other instances, not just freedom suits, but instances. For instance, Sojourner Truth's son is trafficked to the South from the North, and he too is someone who was entitled to his freedom. So these aren't just sort of freedom suit cases; these are other instances as well. If you have any kind of inkling of any of these things, please let me know. Needles and haystacks are hard to find. So.
Okay, unfortunately we're out of time. Sorry, Bob. Please come up and ask it directly to the panelists, but let's thank them for an outstanding panel.